So let's take on two legal developments, one down in Georgia involving Donald Trump, Rudy Giuliani, and some others, and the other in D.C. involving Mark Meadows. But to be honest, friends, at the moment I feel like we're just treading justice water. But let's talk about it, because justice matters. Hey all, Glenn Kirshner here. So we got what I would call some minor legal developments about Donald Trump and some of his lackeys and lapdogs, criminal associates, co-defendants. What a motley bunch. First, let's talk about the ongoing criminal investigation being conducted by Fulton County, Georgia District Attorney Fani Willis. Here's the most recent reporting. This from the Washington Post. Headline, Georgia 2020 election inquiry may lead to prison sentences, prosecutor says. Well, that's nice to hear, because that is sort of what should happen when one commits serious election crimes. That article begins, the prosecutor investigating efforts by Donald Trump and his allies to challenge the 2020 election results in Georgia said this week that her team has heard credible allegations that serious crimes have been committed and that she believes some individuals may see jail time. Quote, the allegations are very serious. If indicted and convicted, people are facing prison sentences, Fulton County District Attorney Fani Willis told the Washington Post. No decision will be made for months on whether there will be indictments and, most notably, if Trump himself will face charges. At least 17 people have been notified that they are targets of the criminal investigation, meaning they could eventually face charges. And more targets will be added to the list soon, Willis said in an interview Tuesday in her Atlanta office. Willis would not discuss any of the targets by name and has not said if she's willing to charge the former president. Trump could be called to appear as a witness before the special grand jury that was convened this spring as part of the investigation, Willis said Tuesday. Quote, a decision is going to have to be made, she said, on whether to seek Trump's testimony, and I imagine it's going to be made late this fall. And let's face it, if Donald Trump is subpoenaed to the grand jury in Georgia, he will likely just plead the Fifth, invoke his Fifth Amendment privilege against self-incrimination, 440 times, been there, done that, in a New York grand jury. The article continues. So far, the group of known targets includes former Trump lawyer Rudy Giuliani and the state's 16 would-be Trump electors who created unofficial, that would be false, documents proclaiming Trump as the winner of Georgia's electoral votes, even though he lost the state. You know, friends, is it just me, or does it seem like justice is taking forever? How many more elections will come and go before somebody makes a prosecutorial decision involving Donald Trump? Let's turn to the second story, this one involving another Donald Trump criminal associate, not Rudy Giuliani, but Mark Meadows. Here's the most recent reporting from CNN. Headline, Mark Meadows complied with DOJ subpoena in January 6th probe. But before we celebrate, let's look at what the article relates. Former White House Chief of Staff Mark Meadows has complied with a subpoena from the Justice Department's investigation into events surrounding January 6, 2021. Sources familiar with the matter tell CNN, making him the highest-ranking Trump official known to have responded to a subpoena in the federal investigation. Well, that sounds promising, but wait. Meadows turned over the same materials he provided to the House Select Committee investigating the U.S. Capitol attack, one source said, meeting the obligations of the Justice Department subpoena, which has not been previously reported. So, Mark Meadows gave the Department of Justice the same stuff he's already given to Congress. I'm not wildly impressed. The article continues. Last year, Meadows turned over thousands of text messages and emails to the House committee before he stopped cooperating. The texts he handed over between Election Day 2020 and Joe Biden's inauguration provided a window into his dealings at the White House, though he withheld hundreds of messages citing executive privilege. And what's more, when Congress subpoenaed Mark Meadows to testify, he thumbed his nose at that lawfully issued congressional subpoena, thereby committing the federal crime of contempt of Congress. There is no two ways about it. There is no open question. He committed that federal crime, for which Congress referred him for prosecution. And a co-equal branch of government, the executive branch, the Department of Justice, said, we're not impressed. We're not concerned. We're not going to charge him with the crime he committed against Congress. We're not going to support a co-equal branch of government by enforcing the law when Congress is the victim. Yeah, I'm still kind of ticked off about that. And some people say, well, maybe DOJ has a grand scheme. Maybe they have, bigger things in store for Mark Meadows. Maybe. But it still, to me, feels like one branch of government acting in a really disrespectful and inappropriate way when another branch of government is victimized by an executive branch official who tells Congress, take a flying leap. I'll tell you what to do with your subpoena. Yeah, I'm still ticked off about that. Maybe justice is coming in bigger ways for Mark Meadows. It better be. Okay, friends, I'm done that particular rant. And I do have two observations about the story, about Mark Meadows complying with the DOJ subpoena and giving the Department of Justice exactly what he has already given Congress. So there are no revelations here. But the two observations are these. First, if DOJ is moving in the direction of indicting and prosecuting Meadows, Trump, other criminals in the Trump administration, then there's an evidentiary reason to subpoena the text messages, the emails, the documents directly out of Mark Meadows' grubby little criminal hands, right? Because yes, he's already given this stuff to Congress, but the prosecutors don't want to be in a position to use these documents as evidence when Mark Meadows gave them to Congress and then Congress gave them to the Department of Justice, because then you have a chain of custody issue. Too many hands on the documents, on the evidence. It's a minor evidentiary point, but I can see why it would be important for the Department of Justice to say, yes, we know Mark Meadows gave this stuff to Congress, but we need him, pursuant to a subpoena, to give it directly to us. So we are compelling him with a subpoena to do that, because we don't want to have those documents pass through too many hands before we get them, if we're intending to use them as evidence in a prosecution. That's one observation. The other observation is I have to believe the Department of Justice is approaching Mark Meadows incrementally. First, subpoenaing the stuff that he's already turned over to Congress, and then maybe subpoenaing additional information, and certainly subpoenaing him for testimony. Because Mark Meadows won't be able to thumb his nose at a grand jury subpoena the way he thumbed his nose criminally at a congressional subpoena. Because if he does, he will be in trouble. He will not pass go. He will not collect $200 or $2 million or whatever it was that Donald Trump gave to Mark Meadows' PAC. Might that have been to shut Mark Meadows up by his silence? I suspect we'll hear more about that in the future. But yes, it feels like justice is treading water, is not moving forward, is not making progress, at least in recent days. But at least we're still afloat. Friends, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.